As global trades become increasingly digital, the ability to verify our organizational identities across borders has emerged as both a legal and a technical imperative. In this episode of Trust Talk, Luca Castellani of UNICITRAL joins me to explore how the model law and the use of cross-border recognition of identity management and trust services, MLIT, alongside GLIFE's verifiable legal entity identifier, can provide a foundation for a future where trust, efficiency, and legal certainty converge. Together, we will break down how these frameworks deliver a powerful combination of legal legitimacy and technical interoperability, enabling governments, regulators, and private sector stakeholders to engage in cross-border digital transaction confidentially. So let's start with introductions, Luca. Can you share a bit of your background and where you work and how we here together talking about this topic?
Thank you. Thank you for the kind invitation, Alex, and warm greetings to everyone. My name is Luca Castellani. I am a lawyer, a legal officer at the Secretariat of the United Nations Commission on International Trade Law, or UNCITRAL. UNCITRAL, which is based in Vienna, Austria, is part of the Office of Legal Affairs of the Secretariat of the United Nations, is the core body in the United Nations system for the harmonization and the modernization of commercial law. I have to say, it's called UNCITRAL. The name makes reference to trade law, but it actually does not deal with the trade law as the World Trade Organization. It deals more with the private side of things, so with contract law and with commercial law. And because of that, UNCITRAL, having already done very good work on uniform contract law, started dealing with the use of electronic communications almost 50 years ago, more than 40 years ago. It's interesting, the first topics that were discussed were payments on the one hand, because already back then payments were necessarily in electronic form, and also EDI, so structured electronic data interchange. But then UNCITRAL moved on to tackle issues of contracts in electronic form. So there is model law on electronic commerce, which now we would not call probably model law on electronic commerce because it deals with electronic transactions. It was adopted in 1996. And then a series of other texts. What is important for our discussion today is, on the one hand, these texts altogether, the UNCITRAL texts on electronic commerce, were adopted in more than 100 states, so more than half of the world. And on the other hand, these texts contain provisions on electronic signatures. Those provisions on electronic signatures, little by little, evolved into provisions on trust services and identity management. So that's the part that we are interested in today, mindful that the issue of identification and although I don't like the word too much, but authentication has always been with UNCITRAL for this work on electronic commerce, but also to enable the use of electronic documents and contracts in our fields.
Very good. So what led UNICITRAL to actually develop the MLIT framework, and what key gaps in digital identity management does it aim to fill in general?
We have had generations in electronic commerce law, or if you prefer, digital trade law. So the first generation, the model law on electronic commerce, model law on electronic signatures, probably the United Nations Convention on the use of electronic communications in international contracts, where still belong to the first attempt to provide an enabling legal framework for the use of electronic communications. I would say in trade, but actually UNCITRAL texts are used for commercial and non-commercial operations. So in this case, to specify that it is for commercial use is not meaningful because it's more practical and the rules apply for trade and not trade. Um, but then there was a small break in the work in this field, and then there was the issue of transferable documents of instruments, which now are particularly prominent after the COVID pandemic. And so in 2017, there was the adoption of the model on electronic transfer records. But by then, there was awareness that we were a little bit changing perspective. In the first generation of uncitral texts, the idea is to enable the exchange of information at long distance, instantaneously, at limited cost, no cost, maybe. But 20, 30 years later, we had this impact of the beginning of a data society. And so after the adoption of the MLITR, there was a strong request, which had already been put forward before, to look especially at the regional experience of the eIDAS regulation and to try to provide a comprehensive framework for data quality assurance. So, and this is like the real change in perspective, the shift, because one thing is to individually share electronic information, like I can scan a document, send it by email. Great job, you have it right away. And another thing is to share data which is structured to be read, validated, analyzed, and reused, which is a completely different thing. And so that has really opened the door to also re-understanding digital trade, thanks to the model law on the use and cross-border recognition of identity management and trust services, as you said, the MLIT. We could then embrace and really support this vision of end-to-end trade digitalization, this vision of, for instance, data pipeline, this vision of having single sources of high quality data that provide us consistent information across the supply chain. And this is totally different because we bring back to unity what was artificially divided in hundreds of paper documents. But to do that, we need to have reliable assurance of data quality. And so we have to go through trust services and also the identity management component.
Yeah. So assurance of data quality and provenance as well, and that's really where the identity component is coming from, right?
Yeah. Identity as a component of the origin/authorship.
Exactly. That makes sense. So of course, in that type of system, if you're talking global interoperability is essential. Not only technical interoperability, but also legal interoperability. I'm guessing. So why is legal interoperability as essential as technical interoperability when we discussing those digital systems, digital trust systems?
Legal interoperability is a beautiful term. It's a new term for us. Let's say if we go with a little bit of a more traditional or conventional approach now, you know, lawyers tend to be conservative. Usually they are. We have a few fundamental principles underpinning our texts, and the one that is the most important for interoperability is technology neutrality. So from our perspective, all of our texts should never mandate or favor any product, technology, method. What we do foresee is the possibility, because all of this UNCITRAL legal construction revolves around the notion of the use of reliable methods. And then the big question is what's reliable. And when we determine what's reliable, then we can also look at the technical standards, of course. But let's say that there are two big issues here. One is the identification of the technical standards that should be used as a benchmark for the determination of reliability, or if you prefer, the assessment of reliability. Now, I would like to say assessment because the second part of it is there are two ways to assess reliability. One is to determine the reliability of the method in case of any issue after its use. But the other is to designate a method, or usually it's not a method that is designated, but it is a service. People think you designate the system or the service provider. No, system and service provider can deliver multiple services. So you designate a service as reliable. And I mean, because I'm a lawyer, that has legal consequences, because if you use a service that is designated reliable without violating technology neutrality, you could benefit from a very big advantage, which is presumption of certain legal, elements like origin or integrity, these kind of things. And the presumption legally is very important because there is a reversal of the burden of proof. If you pass the burden of proof to the other party, the other party has to, start from scratch and put together everything, which is very difficult. So this reliability issue is really at the core of the whole system. And we didn't have a lot of discussions up to the model on electronic transfer. And then we started having a lot of discussions. People were very worried because of the value of these documents. And then the industry came up with some guidelines that are evolving into standards. But this was more self-regulation. And it's important because the industry normally knows better in these highly sophisticated environments. Now, for identity management and trust services, I would say we know that there are different standards, but these are regional or maybe even national, but have a big impact. But we don't have yet a global standard, and which creates the issue for the recognition. Now, you said interoperability, but in reality, yeah, I like legal interoperability, but in reality, legal interoperability means cross-border legal recognition from a legal perspective. So it's not it's the same but different.
Understood. Well, the ambition of the legal entity identifier system and the verifiable legal entity identifier system is to be that global protocol, actually, and standards that can be used to bridge national or regional frameworks, and to enable that interoperability at cross-border level. Um, are there room in the current, I would say, um, documents or rules of the game that has been defined so far for those global solutions to enable that interoperability that we just discussed, both at um, digital infrastructure, digital trust infrastructure level, but also at identity, organizational identity level?
The MLIT is all about promoting cross-border recognition. It's a foundational element. And it was drafted bringing together two main streams, the one coming from EIDAS and the one coming from pre-existing UNCITRAL texts. So when you look there is a list of elements that are usually relevant. The list is open-ended, and not all elements are equally relevant. But there is this list of elements, and of course, international standards are in the list, but it doesn't say which international standards. But of course, one would say, well, I'm using this solution, which is widely accepted all over the world, and that's an important statement. So that helps. And not only that, but the same list can be used to designate the services presumed reliable. So I think that there is an opportunity there if more jurisdictions adopt this model law nationally, because of course it has to be enacted at the national level to be effective. If that happens, then there is an opportunity for the supervising entities to determine that the services using, in this case, I would say the vLEI, would be presumed reliable, which is, of course, as I said, a very big step forward. It's so yes, there is, and there are mechanisms, very interesting mechanisms. Uh, First of all, the even the well, either the designation or the determination of reliability take place on a geographic neutral basis. So looking at the technical issues and not at the place of origin or use of the service. And then also there are other provisions that really give you the more opportunities. In particular, there is guidance on cross-border recognition. If the technical standards are identical, then the same level of assurance or level of reliability, depending if it is an identity management scheme or a trust service. And then if the descriptions are different, or one jurisdiction doesn't have any description, then there is this notion of substantially equivalent. Substantially equivalent means we don't look at the formal description, but we look at the practical, impact and the features. And if we can achieve the same features despite different design and different description, then okay, fine. When we substantially equivalent. So basically means at least fulfills the same functions of the required level of assurance or level of reliability.
In that recognition or cross-border recognition of approaches and frameworks, one of the core element is the identity system that is used in each jurisdictions to identify legal entities. So we know that generally every country and sometimes regions have their own identity system for businesses. The legal entity identifiers has been created for that reason in 2008 after the financial crisis, because those national silos, I would say, were preventing a global visibility of entities in the financial market, in capital markets. Do we have the same challenges in trade? I would guess yes, because we are engaged in conversations to leverage the legal entity identifier as a way, the LEI as a way to make those national identity system interoperate. Do you share the same, um, um, I would say, fear, or not maybe fear, but at least wish that national system could be made interoperable through the use of international standards such as the LEI?
Please allow me to share a couple of
Please do.
unconventional considerations of this. There is a bit of misunderstanding because there's different things here together. I think, although this was not particularly discussed even at UNCITRAL. I think the identification of legal entities, corporate, not corporate, whatever you want to call them, but I think this is the easiest use case because on the one hand, the vast majority of these entities go through a formal process of recognition. Now we can start a discussion on this is gonna penalize the informal sector. Okay, fine. I'm mindful of that, but I also have to have a practical discussion here. So let's assume that the profit will go to the commercial registry and the non-profit will go to some other thing, whatever it is. And because of this process, it's easy to assign a unique identifier. Now, we can use that unique identifier as such, or we can use it as a reference to another persistent ID, which could be your solution, of course. But then we just ask to use that identifier and that's it. So, and we don't really have, we may have a desire for, there are issues like sometimes commercial secrets or anyway, some things which are a bit more delicate. But in reality, from the point of view of enforcing regulation and monitoring compliance, there should be no such issue. And we don't have the dramatic problem of data privacy, which comes up with physical persons. And I would add to that, actually, that the whole discussion that we are having with foundational and transactional identity when we discuss in physical persons, in order to protect the privacy of physical persons. I may be wrong, but I don't see the same arguments for this kind of legal entities because at the end of the day, they should behave according to the law and do what they have to do. So, and of course, there is always the possibility of misuse and abuse. There should be measures in place to ensure that information is not shared inappropriately. But nevertheless, I think that we are going in that direction, especially there is a big drive because of these revenue issues, not just compliance, but also collecting the tax and other kind of. So we have two things there. The solution for the corporates, it works very well, in my view. And in my view, there should really be, yes, there may be some resistance due to existing practices and vested interests and things and one thing and the other. But in the end, this is not, I don't see any argument that cannot be overcome to that kind of solution. But the problem is that a lot of the discussion is tainted with the considerations for physical persons, which are totally different. And so we should be able to separate and solve the easier problem. And another level of complexity, which however is overlooked, is the inclusion of in this picture of objects. To me, objects are the most important in trade because they are the ones that generate the most data. We have the ones on which we rely as oracles for automation, for many things. But there is not yet a desire to have this a structured discussion on objects. And I find it a bit of maybe it's just a technical matter, maybe not really. Maybe it would be good to spend time, even in the legal field, to find out how we can deal with objects. But objects is the same if digital or physical. They should have a unique identifier. They should be associated with a physical or a legal person to make clear that objects don't have they are not, they are objects, they are not a legal entity. And but we should be able to trace all of this immense amount of data that is generated permanently and put objects in the picture. Uh, Without, I am the first person to say there is a very dangerous trend to anthropomorphize everything in the digital space, and it's wrong. The virus, it's not a virus. The artificial intelligence is not intelligent. The smart contracts is not smart, and it's not even a contract. All of this stuff which we bring back, and it's wrong because it's a wrong description of what it is. But I insist, objects should not be independent, legally speaking. They should not be a subject of rights and obligations. But there should be a way, like we do for website authentication. We don't have a problem with website authentication. So we could do it for any app, but but somehow it's difficult to say that. So it was not so conventional.
No, it is interesting because we are in conversations with quite a few industry groups and associations, but also actors in the trade space around the benefit of a organizational identity and verifiable credential system like the vLEI to actually tag those objects you just mentioned to a legal entity, the same way that the vLEI enables to um, uh, have an individual acting on behalf of a legal entity clearly identified as such and verified as such, rather. You can also do the same for objects and systems and AI agents, for example. So we're already experimenting with the use of the vLEI as a way to issue credentials to a computer, to an IoT device, or to an AI agent to verifiably prove that object is acting on behalf of a specific legal entity or is in relation or in engagement with a specific legal entity. So um, non-conventional at all, I would say. I think it's the debate of today and in the future in
I
that
am
space.
very happy to hear that. I tried to have the debate before, but I was maybe ahead of my times. I don't know, or behind. I
Probably,
don't know why. Anyway, it not in sync, but
yeah.
but it's good.
Well, that's
It's good.
yeah, it's actually the problem with new technologies sometimes when you know that they're able to do stuff that were not possible in the past, people still think that they're not possible. So nobody thinks about those considerations before people like you and others start thinking about it, right? So it's good to be ahead of our time, of our time from time
From
to
time
time.
to time.
Um,
Yes,
well, sometimes we are looked at bizarrely by others, but that's fine, I guess. Uh,
true.
so, in that context of use cases, actually, we just mentioned a few use cases around objects, but also contracts we mentioned before, and documents, and who provenance of documents, provenance of data, validation of data. How can governments, trade platform, or other stakeholders, I would say, embed all the work that you've done around MLIT and others, and potentially the vLEI system into their digital trade infrastructure? How should they go with adopting those frameworks?
When we talk really about, because before we were discussing the, let's say, MLTR, when say you have like a system for managing electronic bits of lading,
Yeah.
which is a good use case, which is attracting a lot of interest now. The industry is behind it. They want 100% EBL by 2030. Maybe it will happen, maybe not, but for sure things have started moving, which were not moving before for a long time for different reasons. Um, the I think that the issues then is once we are done with thinking about the reliability of the method and we look at the trust services behind, then we appreciate what we are trying to do and why and how. Uh, the MLIT, unlike EIDAS, has a definition of trust service which I find particularly useful. As a trust service is just a service that provides assurance about data quality. Of course, it's neutral. It's any assurance. It can be also zero level
Mhm.
assurances. It's a trust service does not give you any assurance. Actually, it maybe you should think about what you are doing when when you find this kind of thing. But I mean, a lot of the things that we see every day have no assurance, so and they exist
Mhm.
nevertheless. So uh, when we start thinking about the different trust services and the desirability, especially to have these, we call it two-tier approach.
Mhm.
So the designation and the determination. That means a lot of a cultural change, because nowadays we find a lot of jurisdictions, as I would say, on the one hand, civil law countries, especially countries in transition, but a lot of developing countries that are looking for very specific technological solutions, which creates a problem
Mhm.
to the general data flow. And then you have other jurisdictions, especially certain common law jurisdictions, that are not accepting even the notion of trust service. And they have a very flexible notion of electronic signature. At least I'm talking about the business side. The regulation could be different. So to me, yes, it is a very long uh, process that requires a lot of investment. Law reform, yes. Uh, Technical infrastructure, yes. But as always, first and foremost, it's a human capacity to explain how things should work and why we can keep flexibility and at the same time have a high level of reliability, and why things should be validated even at the judicial level. So um, it would be easy for me to say, well, if all the countries will adopt the MLIT, no problem will exist. Not really. There will still be problems, firstly, because MLIT relies on the existence of appropriate solutions and appropriate technical standards,
Mhm.
which of course are not in the law. And secondly, because even in Europe, we have still problems with countries that say think only qualified trust services are worth something, which is not true. It doesn't reflect the daily life of business or even of social life.
Mhm.
We have, we are constantly signing things all the time inadvertently, and all of these things can be used against us.
Mhm.
So from a legal perspective, it's even a bit overwhelming. But even the self-driving car, I mean, I very much doubt that it uses qualified electronic signatures,
Mhm.
but there's a lot of legal consequences attached. Maybe it does someplace, I don't know. But normally I wouldn't imagine that. So we needed to have a bit of a cultural change to find a way in between too much laissez-faire and too much regulation, as always.
Finding the right balance, the challenge of humanity about anything.
Yes, that is.
And
That is it.
so how do you see the next 5 years, I would say, of all these discussions we're having? And what do you predict in 5 years we will have now that we don't have yet achieved right now?
I would say that it's two different things. One is, in general, there will be more demand for compliance.
Mhm.
So, because, the overall trends are clear. I mean, there is more friction everywhere in trade,
Mhm.
in our fields. And we have been comfortable with certain things. Um, for instance, I'm sure the same happens to you. In many of these discussions, people look at passports or biometric passports as a golden standard of identification. And I was never convinced. Uh, and then I found out that airlines know that there is I don't want to say vastly inaccurate, but somewhere in between 1% and 2% of the passports that don't fully match the passenger.
Mhm.
And they said it because when there is, most unfortunately, an airplane crash, we need more time to find out who the after victims are. And so I think, well, you think that as a golden standard, but I would never think that as a golden standard, because 1 to 2% is very inaccurate. Now it can be different depending on the region, depending on the type of passport. Maybe this is a discussion that it does not apply to biometric passports, but only to traditional
Mhm.
passports. I'm not a passport expert. I'm just trying to draw a comparison. So that sometimes there are identity credentials that we are familiar with, but in reality, they are not as good as we think they are, just because our identity credentials are reliable, our own, but we don't know the credentials of others.
Mhm.
So that's what I'm trying to say. And also the way we use them, because I take it, for instance, that when I use a biometric passport at the gates of the airport of Vienna, every time the gate gets to know me a little bit more,
Mhm.
and the validation is a bit faster. So this is becoming a process that is not just credential based, but it's based on iteration.
Mhm.
So it's different, and it's better, and it's more interesting. And because of now technology allows us to do so, so there will be a change in that regard. So not only having reliable credentials used in a certain way, but also monitoring patterns, monitoring use, having profiles, anonymized, of course,
Mhm.
with all privacy we want. But I think that will be the significant changes and significant improvements in that regard. Uh, I don't know what will happen to the MLIT. I hope that more jurisdictions will consider it, but because it was originally conceived as an interface to EIDAS, I think that one important point would be really to promote it as such. So those countries that want to have commercial and electronic exchanges with the European Union, this could be particularly useful. EIDAS 2 also has changed a little bit,
Mhm.
because originally EIDAS had a very high requirement for interoperability and cross-border recognition. Now it can be done in a little bit easier way. Um, of course, a lot of work is still there, but the probably the fate of the MLIT is related to that. I hope it's not a model law a bit ahead of its times. I hope that now it will be discovered and enacted more. Although I have to say, and maybe I would like to know your views on that, but many countries, they decouple identity management and trust services.
Yes. It's they decoupled, or they try to couple it in a way that is a bit artificial. Sometimes leveraging what has been built for individuals or physical people to try to fit into a organizational identity or and trust system requirements, which is not always working technically. So that's really something that we're observing. I think the debate here, and that involves EIDAS 2.0 as well, by the way, is that what has been built so far is very focused on individuals. How do you evolve such system to be fit for purpose for organizations in a way that is robust, that is that cannot be tainted with in terms of attacks, for example, and that can be therefore trusted in those in trade and global trade and finance as well. So that's what I see, and we clearly working on ensuring that the technical protocols used uh, for organizational identity and verified credential system linked to organizational identity are thought at the level of an institutional grade solution or organizational grade solution, and not an individual person grade solution, if you see what I mean.
Yeah, and that's I thank you for that, because that's what I mentioned before. But the legal entity use case is a bit easier, but a lot of the analysis is influenced by the physical person use case, which is much more difficult. But yeah, for us, many countries, they want to do trust services. Maybe they want to expand electronic signatures to electronic seals and timestamps, or completely different and separate. They want to do identity management, but then instead of appreciating the possibility of having different identity management schemes, private, public, then the desire to promote national electronic identity cards prevails. I mean, very useful, very useful, mm, for the purpose of trade or compliance. I mean, we can discuss to what extent very useful.
So,
I would say compliance of individual, yes, not corporate compliance.
absolutely. So, I wanted to ask you as a last question, if there was one thing you would want our uh, listeners or watchers or spectators to remember from our conversation today, what would it be?
I always say, uh, think data, not documents. So I would say in this case, think validating data, not authenticating documents, or something like that. So they have to we they have to look at what's behind.
Understood. So, data at the level of data rather than at the level of the document, which includes multiple data and multiple source of data as well. Actually, makes a lot of sense. Thank you so much, Luca, for this conversation. And I think it was very. I learned a lot because I'm not an expert in your fields, and uh, looking forward to working with you and UNCITRAL in the future to make this a global interoperable trust system more a reality over the next 5 years.
Hopefully, thank you so much.